Hi, everyone. Welcome to our Y Education series. Tonight, I'm very happy to welcome Mike and Randy from Oak Wealth Advisors. They are here to discuss able accounts and special needs trusts. On behalf of the YMCA, thank you so much for your time and your expertise. And I'll let you guys take it away from here.
Well, Amy, thank you so much. Thank you to the YMCA for having us tonight, and thank you for all of you tuned in tonight and those of you who'll be watching on the recorded version. I'm going to go and try to share my screen now, so we'll see if my technology skills allow us to advance the slides. Tonight's focus is going to be on two very technical topics, and my intention is to make them much less technical and more approachable for everyone who's doing planning in the disability community. Those two topics are going to be special needs trusts and ABLE accounts. And on this very first slide, you see a picture of me and my brother during the last set of holidays, the end of 2024. And behind us is a picture of us at a golf outing. The reality is, he is my why. He is the why for Oak Wealth Advisors existing. He is 2.5 years younger than I am, was born with multiple developmental delays, and at age 32 was diagnosed with autism because when he was born back in 1969, autism wasn't a thing. It wasn't a diagnosis. So we've come a long way. And he is in a really good place as an adult. His future is well established, and he's worked at the same job for 25 years. That's now coming on for all of our loved ones. But my parents had so many challenges, made so many mistakes along the way because there wasn't good information. My goal for all of you who are listening is that there'll be a couple of things you learn from this presentation that'll help you with the planning for your family and your loved ones to hopefully make things a little easier than they were for my family and for all the families that we've been assisting. And just so you know, everyone at Oak Wealth Advisors has a loved one in our own immediate families with a disability. And so with that, I'll let you look at some of my background there. No need to read it all. You can go to our website, oakwealth.com, and read more about me and our team. But most recently in 2023, we won an award in the DEI space for the National Association of Personal Financial Advisors for the work we do serving the disability community, which is often an overlooked group with high unemployment and lots of discrimination, as you all well know. So we're able to bring and shine a light on that community and the financial planning work that our firm has been doing. We've also won some awards for financial planning. You can read all about that later, but more importantly, let's get to the materials that you guys want to learn about tonight. First of all, I will start with my colleague, Randy Gillespie. You might have seen during the introductory comments that Amy made, she'll be manning our chat tonight. So if you have a question, whether it's pertinent to everybody or specific to your family, feel free to put it in the chat. If there's something I was discussing, like I want more information about that, tell her. Randy will stop me. We'll go back and revisit a topic if we need to. I'll clarify something if I wasn't clear. And Randy can also answer some individual questions directly, depending on what the topic is. And by all means, we hope to have at least 5 minutes at the end to take additional questions from all of you. And you can see there, Randy herself has a loved one with a disability, and she's been very involved in the Northbrook community with planning and support, and even working with the county government to bring more inclusion and more awareness about disability needs. So tonight in our discussion, I'm going to try to use person-first language the majority of the time. That means saying the person with the disability as opposed to the disabled person. Now, some people don't care. Some people get really anxious if you say it a certain way. If we're meeting with you and your loved one one-on-one, we'll use whatever form of language introductions you prefer. In a group setting, we'll lean towards using person-first language, but at times I might use identity-first language just to ensure that I upset everyone equally. That's definitely not the intention, but I know that's what happens in these kinds of presentations. We've done them many times. So what is it that we and other special needs planners do for families? So what's kind of our role? What can you learn from a special needs planner? Well, it's everything from helping families access and maintain government benefits, making a plan for their future, both in terms of financial planning and dollars to support things, as well as caregiving. Who and what is going to provide the care and how much care is going to be needed? Those are all kinds of things we work on with our clients. Also, structuring a family's estate so that the highest level of independence can be maintained by the individual. The most decision making can be available to that person, but also providing the protections that are needed. And for every individual, it's going to be different. So making sure that you've understood everything that's available and putting the right pieces in place for your family. And looking for additional resources. We're constantly learning new things about the industry. We're finding new great role players that we plug in with different clients and different families. And so you want to have a planner who can help you find those resources when you need them. And obviously, we want to protect our loved ones from both creditors and predators. It's probably one of our clients' biggest concerns, and oftentimes they don't bring it up until the 5th, 6th, or 20th meeting, but it's always in the back of their mind. What if someone takes advantage of my loved one? So you want to have a planner who's aware of those kinds of challenges and can help you sort through the potential solutions. And then finally, someone can advise you on the technical way to transition your wealth to the loved one or loved ones in your family who might need some additional support. And so tonight, the focus is going to really be on maximizing public benefits through the use of special needs trusts and ABLE accounts. As you're probably all aware, we can get benefits directly through our school district, through the public schools, through, in Illinois anyway, through the year in which they turn age 22. So as long as they turn 22 after the start of the school year, they get to finish that school year, and then they stop getting supports through the school system. That was one of the very few benefits that was added to the public benefits support system during COVID. Prior to COVID, our loved ones would graduate on their 22nd birthday. Didn't matter if that was right in the middle of the school week, that was your last day. Now, that individual can finish and graduate with their class at the end of their 22nd year in the school system. The challenge then becomes, then what? Right, the transition process of going from all my sports are coming through the school district, I can ask them for what I need, and they help us find those resources, to, now what? It's up to the family to figure out where the income's coming from, where the healthcare is going to come from, who's going to pay for food. All those things that the school will provide if you can't provide for yourself is now on the family to find for their loved one. So making sure the public benefits are thought through, applied for successfully, and then maintained. The challenge is going to be in the maintenance. Not only do you have to keep great records, but there's a number of hurdles you have to keep getting over on a month-to-month basis to ensure benefits are maintained. And by understanding how special needs trusts and ABLE accounts can work to make that easier, hopefully after tonight, you'll have even more success keeping the benefits for your loved one. So what if you're planning on moving? I mentioned that in Illinois, we're going to get benefits through our school system through the year in which the person turns 22. Those are all the blue states. That's the same time frame. For most states, you see those in purple, it actually stops at the end of the school year in which the individual turns 21. There are a few states that are even shorter than that. The yellow ones, Iowa, Colorado, and Kentucky, benefits stop on the person's 21st birthday, regardless of where they are in the school year. And the one outlier is our friends to the east, Michigan. In the state of Michigan, as of 2025, and we're recording this on September the 16th of 2025, if you live in Michigan, you can keep getting services for your loved one through the school system through the year in which they turned 26. So that's the one outlier. Everybody else is 21 or 22. So what kind of benefits are we looking at maintaining? This is a whole separate session that we can do on public benefits. Let me give you the highlights, and this is in your handouts, which you can download tonight if you haven't done so already. The two primary benefits are the means tested benefits, basically for the disabled and poor. Those are in yellow on the bottom of your screen. And those that are based on a work history for someone who becomes disabled or their disability becomes so severe they can no longer work. Those are in blue on the top. So the income benefit is known as supplemental security income, or SSI. That's a benefit of roughly $1,000 a month. It's $967 for 2025. And if a parent provides free housing and does not charge rent to their loved one, that $967 benefit gets cut in roughly a third down to $645. So there's a planning opportunity there, right? You could charge your loved one rent, and out of that SSI check of $967, they could give their parent the amount they're otherwise going to lose if the parent provides the rent for free. So that gets a little money from the government with some planning there. And that SSI check, that's what they're supposed to live on. That's supposed to provide for their housing and all their living expenses. We don't have time tonight to talk about whether or not it's reasonable or not, but that's what the number is. We want to make sure we maintain that. That roughly $1,000 a month over a person's lifetime is more than $1.5 million if we inflation adjust that. It's an enormous benefit we want to make sure we get for our loved ones if they're eligible. In addition, Medicaid. We often think of Medicaid, when we hear about Medicaid in the news, as being health insurance, the payer of last resort. That's true, it is. It is medical care. It's doctors, medicines, and hospital stuff. But it's also something else that's very important that has nothing to do with health insurance. And that's how the services are provided when you leave the school system. The Medicaid waiver programs are the kinds of supports that your loved one is getting in the school system. So whether it's going to be vocational support, daily living support, coaching, whatever the individual might need, maybe even just respite for the parents for providing care themselves so that they can get out of the house and they've got someone trusted that can care for their loved one while they get out, have a date night, maybe even take a short trip, whatever that looks like for the family. Those are Medicaid services. So we want to make sure we get eligible to get the SSI benefits and the Medicaid benefits for our loved one over the course of their life. The other piece, which isn't on this screen, which is also a government benefit, is food. That's under the Supplemental Nutrition Assistance Program, or SNAP. That's between $200 and $300 a month of food. So combined, that's what someone is eligible to receive if they don't have any assets, they have very limited or no income, and they're disabled. So if you meet that qualification, and that's a whole separate training session, you should be able to get those benefits over the person's lifetime. If the person is higher functioning and they have the skills and abilities to work, making $1,500, $2,000 or more a month, that's considered to be substantial gainful activity levels of work. Therefore, in the government's eyes, no matter what your disability might be on paper, no matter what the medical profession may have said, if you can earn that kind of money, $1,500 to $2,000 a month on a continuing, ongoing basis, you're not, quote, disabled. You may have a disability, but you're not disabled. But let's say you work for several years and all of a sudden your disability gets worse, something else happens, and all of a sudden you can't work anymore. Well, just like any of us who may lose our job because of a disability, we can get SSDI, Social Security Disability Insurance Payments, which is essentially starting your Social Security distributions that you normally get in retirement at an earlier date at a somewhat reduced level, but yet it replaces the income you would have otherwise had. So if you generate enough work credits, even your loved one with a disability might get SSDI if they're working at some point during their life when they're younger. Then they would also get Medicare after 2 years of receiving that income benefit. So it's possible in some circumstances that the individual remains eligible for everything you see on the screen. They could have the greater of the SSI or SSDI payment. You don't get one plus the other, you get the maximum of both. Whatever the highest number is, you actually get two checks, but it's going to be comprised of whatever the total is of the greater of the two numbers. You also could have both Medicaid and Medicare. Medicare would obviously get you a little bit better medical support than Medicaid does, but Medicaid provides those waiver services that Medicare does not. Medicaid will pay for long-term care. Medicare does not. So nursing home type things only covered by Medicaid. So ideally, we want to make sure that our loved ones become eligible and take advantage of everything on this screen. In order to do that, we need to make sure they don't run afoul of any of the rules that you have to have and understand to be eligible. One of those rules is not having more than $2,000 of financial assets. Probably already knew that. But an individual can have a house and a car that they own outright of any value. But beyond that, it's essentially just $2,000 of financial assets. So whether that's a savings bond with their name on it, they got when they were a baby, whether that's being named on a joint account with a parent, that account had better be less than $2,000 because the entire account will be an available resource for the individual. And if that account's more than $2,000, they're not going to be eligible for SSI and eventually might lose Medicaid as well. So we want to make sure that any monies they have are in the right kind of an account. Well, there's two kinds of accounts that won't jeopardize those benefits: special needs trusts and ABLE accounts. So let's look at those in more detail. I just mentioned what you're allowed to have. This is a slide you can keep handy. This is what a person can own and not run afoul of the means tested benefit level to get SSI and Medicaid. Okay. There are some very limited amounts of life insurance and burial funds. And if they're actually running their own business, they could have whatever it takes to generate that product or service that they're selling. But beyond that, really, it's a house, a car, and then $2,000. So the trust. The special needs trust is really the cornerstone of good special needs financial planning. And a couple points in this slide are really the most important things to remember. You want to make sure that your trust is drafted by an attorney who specializes in this area and is aware of all the Social Security laws and regulations. Why does that matter? Well, I'd rather pay a little bit more money and get a document that's going to work and keep my child eligible for the rest of their life than go with someone who's a little bit cheaper or who's my good friend who I went to college with and did the closing on my house sale. It's kind of a generalist, because if that attorney happens to draft a basic trust and has certain language in it that the Social Security Administration finds to be off-putting or not meeting the qualifications of a proper special needs trust, if there's money in that trust, the kid's going to be denied benefits. And then we have to go through an appeals process, which is both expensive and lengthy and emotionally draining, to be perfectly honest. So we want to make sure that the trust is drafted correctly. How do you know if it's drafted correctly? You're not an attorney. I'm not an attorney. Answer is as follows. Ask the attorney you're considering using for a couple of names, 2 or 3 names of individual families for whom they've drafted a special needs trust and for whom they have a child receiving means tested benefits. So if the kid's getting SSI and Medicaid and there's money in that trust, the government's seen it and the government's approved that trust. That's the kind of document you're going to want. One that definitely has been approved by the government in the past. The document you want will obviously have your kid's name all over it and be specific to your family, but you want someone who knows how to draft in a way that the Social Security Administration is going to accept the document. What's nice about a special needs trust, look at that second bullet point. It can hold any amount of money. So it's truly the type of entity you want to have to supplement or support what the government's going to provide for your loved one. If you can add to that 10,000, 100,000, or $1 million, that's awesome. That's more money available for your loved one, but it shouldn't cause them to not get the government benefits. We want to use both. We want to keep access to the government resources and then make sure that whatever the family's resources are that can supplement that are held in a special needs trust or an ABLE account. We'll explain which one we use in different circumstances. But those are disregarded types of accounts. So a special needs trust, like any other account you might open with a financial institution, it's based on a legal document that's called a special needs trust or a supplemental needs trust. There's other names the attorneys might use, but effectively that kind of a trust. And the assets in there are never going to be deemed to be the individual's own assets. A super important distinction. Okay. One of the things that makes it so, the reason why the government will overlook those assets and not attribute them to the individual is the third bullet point. Only the trustee can determine if a distribution is going to be made. The individual, him or herself, cannot demand a distribution, which is often the case in most other types of trusts. In most trusts, a beneficiary can simply make a request of the trustee, and the trustee is the person who has the decision-making authority and really is responsible for managing the trust. They can say, hey, Mrs. Trustee, I want $2,000 for a vacation. Fine. Distribution's made, the person spends it on a trip. And a special needs trust, the trustee's got to make that decision. And they can say no, because they have the unlimited ability to make decisions, yes or no. It's not considered to be the individual's asset because they can't control it. That's the important factor there. It's also the right naming for anything that has a beneficiary designation. We'll touch on this a little bit more later, but if you've got a retirement plan, a life insurance policy, we don't want your loved one with a disability that we're planning for to be named directly on a plan. IRA, 401k, 403b, any kind of company retirement plan, any kind of life insurance. We want the special needs trust for their benefit named as the beneficiary for their share of whatever that's going to be. Okay.
Excuse me, Mike,
That's
we have one
beneficiary
question.
designation. Go ahead, Randy.
Does the state of residence matter when drafting a special needs trust?
Good question. So a special needs trust is going to be set up based on national laws, but what I didn't mention about those means tested benefits is that Medicaid is delivered at the state level. So each state Social Security office is going to be evaluating the family's application for the individual to receive the SSI and Medicaid benefits. So if there's certain nuances in a state, you want to make sure attorneys in that state where you're applying for benefits have at least looked at the trust if it was pre-existing from another state's draft, and make sure it still works for that home state where you're going to be applying for benefits. In many cases, we have clients who are moving from state to state. We may not have to have the trust redrafted, but I certainly want to have an attorney who specializes in this area read the trust to make sure there's no language in there that might cause the new state to not keep providing benefits. Okay, the laws they're working around are national. So a well-drafted trust should work anywhere, but we want to have an attorney in the home state at least review it to make sure there's nothing that might jeopardize it for that home state. And again, we're not attorneys. We really do believe you should be asking an attorney questions like that to make sure that everything that you want done works for the state where you are. Thank you for that question. Okay, so let's talk about the kinds of special needs trusts. And again, the term special needs trust and supplemental needs trust get used interchangeably. It's incredibly frustrating. You have my sympathy. When I first got into doing this kind of work about 20 years ago, I realized the acronyms in the disability community are so confusing. And they make it harder by using multiple names for the exact same thing. You can go to a conference and hear different people referring to the same kind of planning in different ways. It seems like they're doing different kinds of planning. They're not. It's all focused on the same kind of things. But within the special needs trust, there are really three types. The primary one that all of you should be most focused on is what's called a third-party funded trust. Basically, a trust that's going to be contributed to by everybody but the individual, him or herself. So siblings, parents, relatives, grandparents, strangers, perhaps. Anybody else but the individual can put money into this trust, make contributions of securities, cash, whatever they want to put in there, they can put in the trust. Trust can hold almost anything. It can own the house, right? It's just a name of an account, but it can't be funded for a third-party trust by the individual. And this is going to be really important when we go through the details. As I mentioned before, like any special needs trust, the individual cannot demand the distribution. And because of that, the assets in the trust are exempt from being counted as an available resource for the individual. The third-party trust, we've seen these, can be millions of dollars. The individual is still going to get $967 a month in SSI payments. Okay, the trust can be used to supplement that so they can do more things and have more access to more different kinds of lifestyle things. Another thing that's important for any kind of a special needs trust, distributions are made for the benefit of, not to the individual. If the trustee were to give the individual $4,000 in cash for them to go buy plane tickets, make hotel reservations, and have some spending money on a vacation trip, that's a disqualifying distribution. That individual now has $4,000 of income in that month, and if they don't spend it by the end of the month, they have a $4,000 asset in their name. That's going to be a problem. They're going to lose those benefits until that gets corrected. So we always want to have the trustee paying for things directly, buying the plane ticket, making the hotel reservation and paying for that. We don't want them giving the money to the person outright. It's just like taking the money from the exempted account and all of a sudden making it an available resource. That's a no-no. Other thing to remember about a third-party trust funded by other people's money is that when the individual dies, and this seems like a no-brainer, but the government doesn't get any kind of reimbursement. There's no tax payment due to them. There's no recourse. They can't come get it. That's not the case with a trust that's funded with the assets of the individual, him or herself. If we get to a place where it took a while to get to the planning, maybe the child's a little older, for some reason the family had accumulated $100,000 perhaps in that loved one's name, and now they want to go get the Medicaid and SSI benefits they heard about. Maybe the child's never worked, but they've got all these assets. So the asset test is going to be failed at the time of application, unless there's a way to get the $100,000 out of the individual's name. Well, I just said on a third-party trust, it can be funded by anybody but the individual. There's a solution then. It's called a self-funded trust. And I mentioned there's multiple names for everything, also called a payback trust. And you look at the last bullet point and you'll see why it's called a payback trust. But if the individual is willing to put their own assets into a special needs trust, a self-funded special needs trust, they can go apply for SSI and Medicaid the next day. There's no look back, there's no issue, everything is forgiven. The money goes into that trust. They can get that $967 a month. They can get the Medicaid benefits and services. Again, little difference here. On a third-party trust, it's possible that you could have another beneficiary along with the individual with the disability. On a self-funded trust, only the individual with the disability can be the beneficiary. Money can only be spent on their behalf. Okay. Similar to the third-party trust, the government's going to look at this. Doesn't matter if it's $100,000, $100 million, it's exempt. Does not disqualify the individual if it's in a properly drafted self-funded trust. But a difference between that third-party trust funded by other people's money and the self-funded trust is that last bullet point. When the individual passes away, assuming they've been receiving Medicaid services, the government is tracking the value of those services. They put a dollar value on those. And when the person passes away, if there's money left in that self-funded trust, the one that allowed the person to get the benefits the next day without waiting for benefits and services, the government gets to be reimbursed through the Medicaid office in that state for the value of all the services the individual received over their lifetime. So that'll probably exhaust the value remaining in the trust. The government's going to get that money. So if we have $100,000 in a self-funded trust and $100,000 we're able to put into the third-party trust, which trust should we spend down first to zero? This one. There's no requirement to do it evenly. There's no requirement to spend down the trust so it's funded first. We want to spend down the trust that has the worst terms when the person dies, and that's the self-funded trust. Third-party trust, no payback to the government. Self-funded trust, the government gets to get repaid if the individual received Medicaid services. So keep that in mind. Both trusts can be useful. If your loved one never had any money in their own name, you may never need a self-funded trust. With best planning, you will never use a self-funded trust, but we know that in many cases, loved ones have accumulated significant accounts by the time they get around to doing the planning. In that case, a self-funded trust is part of the solution. There's one other kind of trust to be aware of. Typically less used, but in family situations where there are fewer assets, or maybe there's not going to be $100,000 or $200,000 or $500,000 from insurance and retirement accounts and the value of a home to fund the trust. Maybe there's only going to be $10,000 to $50,000 of dollars that the family can contribute to that loved one. There's something called a pooled trust. A pooled trust takes smaller amounts from multiple beneficiaries, puts them all together in one big pool, and that pool of dollars is managed as if it's one single account, because it is one single account with lots of accounting rules as to who gets what share coming back out. So if I was to put in $50,000 for my brother, he could take out $50,000 over his lifetime, plus whatever the growth is on that $50,000 within the account. So there's like separate accounting for each beneficiary, but it's managed as one account with professional management at the trustee level and professional investment management of the assets. So for smaller amounts of money, the pooled trust can be a wonderful solution when you can't get a professional trustee or professional investment advisor to manage a smaller portfolio with less than $100,000 in it in many cases. Same rules apply. It's got to be drafted correctly. These are all in existence, so you know it's safe to put money into it. They're already operating. The government's already reviewed them. Assets are exempt, so you can keep all those government benefits. But like a self-funded trust, when the individual passes away, any remaining share of that pool goes either to the pooled trust itself for the benefit of the other people in the trust, or it goes to the government to repay them for those services received. Okay, so for smaller size family assets, if there's not going to be enough money at the end of the life to create a special needs trust with professional management, you can use a pooled trust. Illinois has 3 right now that I'm aware of, all of which have more than $10 million in them. So lots of money there. They're going to be around for a long time. They're growing in terms of the number of people using them. They're a wonderful resource for a lot of families. So keep that in mind as a solution if you don't think you have the resources to go out and get an individual trust for your loved one. Any question about those three kinds of trusts?
No, it looks like we're good.
Okay, thank you. So who should be a trustee? Well, in many cases, families come and see us and they assume that a sibling or a relative is going to be named as trustee. In almost every case, the mother or the father or both will set themselves up to be the initial trustee, the initial decision maker. Well, that's fine. That's certainly the most cost-effective way to do things because typically those trustees won't take a payment. So there's more money there for the beneficiary, which is great. But look at all the trustee responsibilities. Do you as the parent have all those skills and abilities? Do you think the person you're going to name when you're gone is going to have all those abilities within your family group? They have to be able to invest and manage assets, potentially millions of dollars. They have to be on good terms with the beneficiary or the guardian if the person's under a guardianship to make sure that communication channel stays open. In many cases, that's the primary reason why a relative is named, because there is good communication lines. That's already been established. That's important. But do they know all the laws related to a special needs trust? Do they know what kinds of distributions are most appropriate? Do they understand the rule that they can't just give the beneficiary money every time they ask for it? And they need to be paying for things directly, not giving them money to buy things themselves. And are they willing to stay current? Will they keep working with the attorney that the family's chosen to be up to date on how the new laws impact trusts? Because there's constantly new legislation. We know that, right? In the last 8 months, we've seen all kinds of new legislation come down and new rules. So we want to make sure we know how those apply to the management of a special needs trust. So in many cases, we're going to recommend to our families that they hire a professional trustee, pay for that service because it's well worth it, then have a relative or a family member supervising the trust company and replacing the trust company if necessary. But it's a lot to ask of a loved one to do all the things of a trustee if they don't have that background and skill set. So be thoughtful about who you're thinking about to name as a trustee after you're gone. So what can a special needs trust pay for? In general, it's not supposed to pay directly for the things the government would otherwise provide. So keep that in mind in the back of your head. So I mentioned basic housing, right? That's going to come out of that $967 a month from SSI. Basic medical care, that's why you have Medicaid. Basic food, that's what the Supplemental Nutrition Assistance Program is for, the SNAP card. Now, can the trust pay for those things? Yes. And recently the laws changed to allow a trustee to make more distributions that don't have disqualifying qualities to them. In the past, if we were providing food directly to the individual, they weren't paying for it, parents just gave it to them, the individual could lose up to 1/3 of that SSI benefit. Okay, that was called in-kind support and maintenance. That rule went away for food. Then there was a change with respect to what about helping with housing? Well, if there's no rental agreement at all, the person's living for free, whether it's with a parent or living for free somewhere else, that is in-kind support maintenance, and there will be a 1/3 deduction in how much they receive. But maybe we don't care. Maybe getting $600 and change is worth it to be in a great location. We don't deal with all the hassle of charging rent. But as I said earlier, if we charge rent of at least the amount they would lose, let's call it $350 to $400 in rent per month, we can get that full $967 check for them. And that might be the better way to go. And so we can also pay for medical care, assuming it's beyond what Medicaid pays for. Or if we've applied to Medicaid and Medicaid won't cover it, then the trust can pay for it. But if the trust pays for basic things like a doctor's visit, not good. Medicaid's supposed to pay that. So we make sure we use the right process for getting things paid, and then we'll be okay. Now, what about other distributions? I mentioned we want to use the SNAP card for basic groceries until the SNAP card's exhausted. If there's no more money left in the SNAP card and it's the last week of the month, fine. Trust can pay for food without any kind of disqualification. We have to have used up the SNAP benefit. Same thing for medical care. If Medicaid can't pay it, then yes, the trust can. Housing. You know what? As long as the beneficiary is paying that 335 under 2025 laws, we're good. The number should be a little bit higher next year. But if they're not paying anything, then all of a sudden, if the trust pays for those things and there's no rent coming back, we have a loss of 1/3 of benefits. Okay, so keep that in mind with respect to distributions. So as I mentioned, as a summary, the special needs trust documents can be the cornerstone of the planning. It allows for an infinite amount of wealth to be available through the family for the individual's benefit without jeopardizing not only the financial benefits, but also the services the person's otherwise eligible to receive from the government. We've talked with a lot of wealthy families over the years, like, oh, I don't deal with that. I don't want the stigma of having this or that benefit program in my family. Okay, fine. Who's going to take care of your kid? Who's going to provide the respite for you all? Who's going to be a trained professional that you can trust your kid to be with, despite their behaviors, despite their communication challenges? Well, through Medicaid, you can find those resources and those people can get paid. It's really hard without it. So I think access to Medicaid programs alone is a reason to have a special needs trust in place, to keep those resources available for our loved ones. Okay, coordination. One of the things that's so frustrating for us is we'll hold our clients' hands, we'll be their guide through the process, we'll educate them about how to use a special needs trust and an ABLE account, which we can get to in just a minute. And then they don't tell anybody they did it. They don't share with their own parents, or if they still have grandparents living, that they've done this work, that they have this trust in place. And that trust is where the money is supposed to go for the benefit of cute little Johnny. Well, if the naming in the parents' or grandparents' estate documents is directly to little Johnny, who has multiple disabilities, now we're going to lose those benefits because now he's going to have assets more than $2,000 in his own name. Solution? We can use the self-settled trust, but now the government's going to probably get some of that money when he passes away. All those problems can be avoided if we share with our relatives that, hey, we created a third-party special needs trust. Please use that name in lieu of Johnny's name outright on your insurance plans, on your retirement plans, in your will if you're planning on passing assets through your will to little Johnny. We don't want it passing directly to him. We want it going to the trust. In addition, after tonight, you'll be more educated and you will talk with the attorney you're going to choose to work with and make sure that you ask what's called a standalone special needs trust. What does that mean? Well, in many cases, an attorney who's maybe not as familiar with this area of work might decide that, well, we can just stick the special needs trust in with the parent's will, that upon the death of mom and dad, their share of the assets are going to pass to little Johnny's special needs trust. It could be written the same way under a parent's revocable living trust, if you have one of those, in addition to a will. The problem with having it written so that it comes into life when mom and dad or mom or dad pass away is what if a grandparent wants to leave $100,000 to little Johnny? You haven't died yet. There's no trust. The trust comes into life when you pass away. Oops. If we have a standalone trust, it says at any time, if anyone wants to fund this trust, it's available to be funded. We don't need somebody to die first. And when you give the document to the Social Security Administration to show them, hey, we've done the proper planning, this trust is well written, and these assets, no matter how many assets are in there, should not count as an available resource for our son or daughter. If it's a standalone document, all the government gets to read is that one trust. If it's part of your revocable living trust with all kinds of other things about your family in there, who's going to take care of what and who's got responsibilities, what kinds of assets do you have? And then there's your special needs trust as part of that. The government gets to read the whole thing. So now you just share with the government all of your most intimate family planning for your estate. They're not entitled to that, but they are if that's where the special needs trust exists. So just give them the special needs trust and only that for privacy purposes and for efficiency purposes. Have it be a standalone document. Okay. So I just went through all the reasons why. Don't need that slide really because I just talked about it. So how are we going to fund the special needs trust? Well, for some people, they'll use a retirement account and say, okay, I'm hopeful that my spouse and I can live on this retirement account and we can leave the entire balance in this one to the special needs trust. That's fine. Retirement accounts are wonderful. Life insurance is more typical. That allows the parents to live on their retirement savings fully and not have to live on less. They need to carve out some money every year to pay for a life insurance policy. Full disclosure, our firm does not sell life insurance. So we get no vested interest in saying to buy it or not buy it. But with life insurance, you then know if you bought the right kind of policy, no matter when you die, there'll be money there to fund that trust. And that provides a lot of peace of mind for the parents to know that no matter when we pass away, we could have spent everything from our own retirement accounts. There's still going to be a big chunk of money there from the life insurance proceeds to fund that trust. So just the peace of mind alone is great. But keep in mind, when you're buying life insurance, it's really hard to understand what it is you're buying. It's like going to a mattress store. It's very hard to compare mattresses from one store to the next. They might be made by the same manufacturers, but they intentionally have different names on them to make comparison that much harder. Life insurance industry is very similar. Lots of glossy names, pretty titles. What you want to ask for is a permanent life insurance policy, the kind of policy that's known typically as whole life, universal life, or variable life. Those kinds of policies accumulate value over time. They cost a lot of money to own relative to term insurance, but if you keep paying the premiums, there will be a death benefit there no matter when you pass away. The problem is that term insurance sounds like the other kinds of insurance, but it has a finite life. Typically, once you reach age 70, term insurance is either no longer available past that age or becomes prohibitively expensive, such that it would make no sense to keep funding the policy. So unless we're willing to die before we're 70, term insurance is not a great long-term financial solution for funding a special needs trust. So we need to work with our planner to figure out what can we afford in terms of insurance, and then what's the right policy to buy that's low cost, but can meet that long-term need we have for funding the trust.
Mike, quick question. Is there any advantage to having the trust own the life insurance policy in
Good
addition to
question.
being the
So-
beneficiary?
Who should own the life insurance? It's probably most efficient if the trust does own the life insurance policy. It's certainly an asset it can own, as long as there's money in the trust every year to pay the premium. That makes sense. So the family could fund money into the trust. The trust can then take that premium or the donation money, the contribution money, and buy the policy or renew the policy premium every year. That's fine. So that works really easily. That way, upon death of the person who's the named individual on the policy, the trust has the money right away. It doesn't have to be. As long as the trust is named as the beneficiary, maybe a parent wants to keep it on the outside for whatever reason. Again, it's a question that comes down to each family's planning specificity and discussing with their advisor and the attorney what makes the most sense. But we've seen it done both ways. We've seen people own them outright. We've seen the trust own them. There's no reason why the trust couldn't own it if that's what you want to do. But you have to have the money in the trust to pay the premium if they're going to own it. All right, let's get to ABLE accounts. With this a little bit more quickly. ABLE accounts to me are the Swiss Army knife of special needs planning. When they first came out, a lot of attorneys weren't real happy about them. They felt people were going to skip over using trust and just use the ABLE account to their detriment. Well, we think it's an and, not an or. We strongly believe you should have a special needs trust, at least a third-party special needs trust, and an ABLE account. The ABLE account can do some things that the trust isn't going to be great at doing. The trust is going to require you to spend thousands of dollars with an attorney to draft the document. An ABLE account is free to open. In fact, you really can't pay somebody because you can't go to a financial services firm or a bank to get an ABLE account. You have to go online. It's the only way to open one. And the only ones you can choose among are through the states. So Illinois has one ABLE account. Other states have one ABLE account. Today, there are 46 state ABLE accounts. There's 4 states don't have them yet. So we want to make sure that we go online. We can open the account for free. The money in an ABLE account, unlike a trust is like any other kind of taxable account. You've got to pay tax on the earnings in a trust. An ABLE account is much more like a Roth IRA account or a college 529 savings plan. The growth within the ABLE account, no matter how successful it grows, is tax-free. Awesome. It's an ideal solution for holding those oops kinds of moments. I mentioned you can't have more than $2,000 of assets in the individual's name. Inevitably, somebody's going to provide a nice gift at some point in your loved one's life. Maybe it's $1,000 or a $2,000 birthday gift. And all of a sudden, we're getting close to the end of the month. And that account where you put that birthday gift is about to exceed $2,000 in the last day of the month. Uh-oh, Social Security is going to see that and stop benefits, at least until you correct it. Let's take that gift immediately and put it right into the ABLE account. The ABLE account's got some limits that a trust doesn't have. We'll go through those in a minute. But the ABLE account being tax-free, easy to open and manage, you pick among like 5 different investment options, from most aggressive growth with mostly stocks down to all of it sits in a cash money market account. And there's different variations between those two extremes. Also with an ABLE account, similar to the self-settled special needs trust, the payback trust, if there's money remaining in an ABLE account, let's say there's $50,000 and the person passes away, and there's no other expenses related to the person's life to pay for. You can pay for a funeral at the end of life, but there's still money left. The government, the state Medicaid office, has a right to request reimbursement for those services. There are a few states that don't. Illinois is a weird state in the sense that the law on the Illinois books says that the Illinois State Medicaid office may make a claim for the assets in an ABLE account of a deceased beneficiary. The current treasurer has said that is not our office's intention to do. So I don't know how you plan for that. I think you have to plan for the worst case scenario that at some point we'll have a different treasurer who will feel differently about how that's managed. And the law says they can come get the money. So you have to assume there's going to be a payback, even though right now we're not aware of anybody in Illinois making a payback to the state Medicaid office. So how do you pick a plan? Well, you can go to our website. Oakwealth.com's got a matrix that lays out all 46 plans side by side. You can look at investment fees, you can look at investment options, you can look at maximum balance sizes, you can compare them and figure out which one you like the best. Again, I'm not going to give you tax advice or financial planning advice tonight, but in Illinois, the Illinois plan is pretty darn good. Okay. Illinois will allow an Illinois resident who makes a contribution into the plan to get a state income tax deduction for up to $10,000 of gifts into the ABLE account per year. So if you're the parent and you want to give your kid 10 grand a year and you put it in the ABLE account, on your tax return, you'll get a $495 state tax benefit for having funded your child's ABLE account. So if everything else looks pretty equivalent to you between Illinois and another state plan you're thinking about, and you only get the tax deduction for contributing to an Illinois ABLE account, maybe that tips the balances towards using Illinois. But do your own due diligence. Use a matrix like ours, or you can go to a couple of online websites that also allow you to compare. ABLENRC.org is one of those. That's the ABLE National Resource Center. There's also one that's managed by the State Treasurer's Office, which has another comparison tool like the one you're seeing on your screen that we created. But I'd encourage you to find the right one for your family and to use it. These are some of the rules for ABLE accounts. First, there is a limit. For 2025, the most you can put into a plan is $19,000. And if the individual is working and does not have a retirement plan available to contribute to at their own employer, they can add up to another $15,650. So conceivably, you could put over $30,000 into the ABLE account in a single year if the person's working. Although to be honest, if they're making that kind of money, odds are the government's probably not going to view them as being disabled. Remember I said earlier, if you can work at a substantial gainful activity level, roughly $1,600 a month of earnings, you're not disabled in the government's eyes. So think of it as basically a $19,000 a year contribution limit. That number is indexed to inflation. It also happens to be exactly the federal annual gift exemption amount. So that's the amount you can give anybody in 1 year and not file a gift tax return, $19,000 for 2025. Now, if your individual happens to have a college 529 plan, you started saving for college when they were born. Relatives might have been putting money into a college 529 plan for them, hoping they'd go to college and that'd help pay for it. Wonderful planning technique. College 529 plans are tax-free. Great way to save. You can actually front load those and put lots of money into them. But if your loved one's not going to go to college, uh-oh, what are we going to do with that 529 college savings balance? Answer is, we could take money from the college 529 savings plan up to $19,000 a year and put it in the ABLE account. Now they can use it for anything, not just education. You can use an ABLE account for education, but you can't use a college 529 savings plan for anything but education. So the ABLE account provides more flexibility for spending that money that may have been saved in a college 529 savings plan. Also, if the individual is not receiving means-tested benefits, I know the focus of tonight's discussion is on people who are going to get Medicaid and SSI, those two primary means-tested benefits along with SNAP. If that's the case, your loved one's working, making $30,000 a year, basically just enough to get by. In that case, if they're not getting a retirement plan account at work, the family and the individual can contribute to their ABLE account and not be subject to any limits other than the state's 529 limit, which for Illinois is $500,000. So the ABLE account could be huge. It could be hundreds of thousands of dollars. It just can't exceed that maximum limit of $500,000. Alternatively, I think it's on my next slide here, and it's not on that one. So if we are getting means-tested benefits, the limit is $100,000. We cannot have our ABLE account exceed $100,000. If it does, the first dollar above $100,000 balance in that account becomes an available resource. So at $102,000, we've now eclipsed, or starting to eclipse, that $2,000 asset limit. First $100,000 is disregarded in an ABLE account for means-tested benefits testing purposes. Dollars after that count towards the $2,000 limit. So again, for receiving means-tested benefits, $100,000 rule, keep that as your maximum size. If, like my brother, you're working, you don't have to worry about that. Your limit's now hundreds of thousands of dollars can be in the ABLE account with no limits and no problem about payback because my brother's not getting any Medicaid services. Okay, so what are the basic rules? One account per individual. You could have both a third party and a first party special needs trust. You can have one ABLE account. That becomes a problem in some cases because of the high level of divorce in our disability community. If one spouse opens the account, once it's opened and it's in the individual's own name, we can't open a second one. The other spouse is going to have to contribute to the existing account. They got to work that out. Also, the individual's disability must have been diagnosed prior to age 26. So if your kid's still in school, not a problem. You can open the ABLE account if you know they have a disability. If it's someone who maybe had a disability later in life, post age 26, they can't use an ABLE account yet. The asterisk is there for a reason. The recent tax law, the one big beautiful bill, there's a little piece of legislation there that says, oh, we're going to change that 26 to 46 on January 1st of 2026. So in a couple months, in January, if the disability occurred for the individual prior to age 46, they can open an ABLE account. Okay, it's a new opportunity that's coming online early next year on the new tax bill that got passed. The individual, him or herself, can open it. They're the ones who have the responsibility for it. So it's their account. They can spend it however they want. You don't actually have to have SSI or SSDI coming to be eligible. You simply have to have a qualifying disability that otherwise would make you eligible for those things, even if you're not getting them for other reasons. Okay, as I mentioned earlier, if the individual is participating in a company retirement plan, the family can still put in the 19 grand and help them, but the earnings amount above that cannot be contributed because they have access to an employer plan. So, little fact to keep in mind there. So why do we like them? Easy to establish, tax-free growth, ignored by the government up to $100,000 for means testing purposes. Above that, it starts to count. Broadly defined expenses. You can basically spend an ABLE account on almost anything. Again, check with your attorney on that, but that's essentially what we've seen happening, is that as long as it's for that person's sole benefit, we're fine. If a person wants to take 20 people to a concert with them and pay for it out of the ABLE account, that's going to be a problem, but certainly their concert ticket can be paid for by the ABLE account. Distributions are easy. In most state plans, there's now a debit card that can be issued, and whatever amount of cash is in the ABLE account, it's not the invested piece, but the cash piece of the ABLE account can be spent off the ABLE account debit card, and there's a record created that gets sent monthly to the beneficiary showing where the money was spent. So if the government ever asks for that in an audit, you can show them, here's where the money was spent. You've got a great record. And the best thing about an Able account for our loved ones who have more skills and more independence, it allows them to spend the money whatever they want without having to ask. That's an incredible benefit. So it's a wonderful independence tool for our loved ones. Limitations, I mentioned the annual contribution limits, the maximum account size for getting means tested benefits of 100 grand. Disability must have existed by a certain age 26 for anybody applying this year. For anybody applying after January 1st, disability age of onset is 46. The investment options are somewhat more limited. In a trust account, we can invest in almost anything we want. In an Able account, we're going to pick one of a set of 5 to 7 different investment choices that the state provides. And as I mentioned earlier, similar to a self-settled trust, there is a Medicaid payback risk with Able accounts. They're similar to trusts in that they're an exempt resource as long as we keep the balance under 100 grand. The assets are protected from creditors to a degree, right? The account is protected if they get sued, but what if someone talks to them and says, hey, let's go shopping together and you can use your Able card to pay for stuff for both of us? The person doesn't know any better. That person taking advantage of them can get access to the money by having them spend the money on someone else. So it's protected from creditors. It's really not protected from predators. Keep that in mind. The assets can be distributed to support the individual in almost anything they want, right? Lots of flexibility for distributions. I mentioned the Medicaid payback. Differences, a special needs trust can be millions of dollars, potentially billions of dollars. Never seen $1 billion special needs trust, probably never will, but there are many that have millions of dollars in them today. A special needs trust can be drafted and customized for a family's specific desires. An Able account cannot. It's here's the plan, here's how it works, you can't modify it. As we discussed, a third-party special needs trust has no payback requirement. Those dollars, when the person dies, can go to other relatives or to charities the family chooses. An Able account is going to either go back to the state Medicaid office or becomes a taxable distribution to a non-disabled relative who takes it over when they're gone. Another thing to remember as well, I didn't talk about this, a special needs trust that has assets in it that generates income, whether it's distributed from the trust account or not, has to file a tax return. Able accounts do not file tax returns. So if you're dealing with $5,000, $10,000, $30,000 for your loved one, an Able account's a wonderful solution. You can invest it, do well with it growing, no tax return required, very flexible distribution. Okay, wonderful for all those reasons. I'm not going to go into this one, but basically an Able account, as I've already said, you can use it to pay for almost anything. In the past, when the rules for trust distributions were more limited, we'd actually have the trust pay the Able account money or distribute money to an Able account, and the Able account would then pay for things the trust couldn't. That loophole is not really as important anymore because now the trust can pay for more things directly. But the Able account has even more flexibility for what it can be spent on. Beneficiary designations. It's one of the last slides I'll leave you with. And I want to just reiterate what I said earlier. It doesn't matter what your will says. Your will might say at my death, 80% of the money goes to my child's special needs trust, the other 20% goes to the other siblings. If your life insurance says 50-50, if your retirement accounts say 50-50 on those beneficiary forms, that takes precedence. Doesn't matter what your will says. The assets in an IRA account, in a retirement plan, the assets on a life insurance policy, all those kinds of things that have a beneficiary. Even if you have a typical joint account at a brokerage place, you can put a transfer on death beneficiary on that. You could literally take an account that doesn't otherwise have a beneficiary and put one on there, just to specify that it goes to the special needs trust on your death. That allows you a lot of control to ensure the money goes into the trust and not to the individual outright. Super important to check what those people have in their records. We've had clients come and sit on our couch with us and swear that for their new employer, they name the special needs trust as a beneficiary after their spouse for the retirement account. So that's great. Let's pull that up online and make sure that's what's in their records, Because even though you might have submitted that and you're sure you did, they might not have typed it in correctly. And in some cases, you all know, the forms that you're given have a very small blank to fill in. And yet the special needs trust name is pretty long. What if they just start typing in your kid's name and stop and don't get the word trust on there? That's a problem. We want to make sure the word trust is on all beneficiary forms that we want to have go to that loved one's trust. Okay, really important there to review that. And then, as I mentioned earlier, tell the relatives you've done the work. Most good law firms you're going to work with the special needs trust will give you a document to share with relatives that says, if you're going to name little Johnny as a beneficiary of your estate, don't. Name his special needs trust, and here's exactly how you title it to go to the trust. That ensures you don't have that situation where there's money in the kid's name at the end of the month. It goes to the trust. Also, if you're going to name a relative to be a trustee, a caregiver, a guardian, some important role in your child's future life, talk to them about that role now. Please tell them you're thinking about naming them. Let them ask questions. Let them say no. Right? Seems like common sense, but people are like, oh, didn't think about that. If you name the person and don't tell them, and then you're dead, and at the reading of your estate, they get told, oh yeah, you're now the guardian and the trustee, and they're like, I don't want to do that. I don't know how to do that. I don't have time to do that. Who are you going to pick next? You're dead. You want to have that discussion while you're alive and you can make the change. Answer their questions, understand any concerns they have. If they're not a good choice, pick someone else, but have the discussion now where you can still make the changes. And then lastly, in my family, there's always a few people who weren't as close to my brother as I wish they were, and they never were comfortable being around him because they didn't really understand. Here, what his quirks are. These things are okay. This is how it's going to work. This is what he likes to talk about. If he's not talking about what you're talking about, it's because he doesn't care. He's very focused on what he likes. If you want to talk about golf or airplanes, he'll talk to you for hours. If you want to talk about something else, he's not going to participate. So have those communications in broader family groups, and you'll have a much more cohesive family in my experience. So with that, we will tell you that if you want to get more bite-sized pieces of objective financial planning advice like you got tonight, we've got a YouTube channel. You can search for Oak Wealth Advisors and find lots of little short educational videos. We've got a Special Needs Voice podcast on Spotify with some leading members of the disability community with some really insightful things and some really exciting things that are coming down the line about what's happening in the disability community. Some real leaders there are sharing what's going on. So if you want to be at the front edge of what's happening, listen to that and stay informed. With that, I have to tell you that nothing I told you tonight is tax advice or investment planning advice. I may have made everything up over the last 60 minutes. I didn't, but I have to say I might have, so I can't get sued. That's what the attorneys told me I have to tell you. So that's our disclaimer. You can read that as fast as you possibly can. It's in your handout, so please read it. But we really did enjoy our time with you all. And if you want to reach out with a personal question for Randy or me after tonight, please do so. If you did not have a chance to share your information with the YMCA that you're going to be participating tonight, you can quickly use your phone and grab that QR code, which is that squiggly looking thing. If you're my age, like, what the heck is that? That's a way to quickly get to a website and a form. Use your phone, it pops something up. You click on that and you pray to God it takes you where it's supposed to go. I promise it's not going to download malware to your phone. At least I was told it wouldn't. So those are 2 QR codes for you to consider working with. With that, I'll turn it back to Randy and Amy for any final questions or words. I'm happy to take any questions you guys may have, but thank you so much for your time.
I'll leave it to you, Amy.
Oh, wow. Thank you. Thank you so much. As always, such a plethora of knowledge. I know there's lots of hoops to jump through and it gets really detailed. So thank you so much for your expertise and your time. I will be sure to send this out to everyone who registered, along with your contact information as well. We've got one more chat with you guys in October, and I'll send that date out as well. I think it's October 7th. And it's the final part of your 3-part series. And yeah, that was it for me.
If anybody has nothing to do on Thursday, September 25th, and you're interested in heading over to Northbrook Book Bin, Mike and I will be sharing stories from our recently published book titled It's Okay to Laugh. And it was a wonderful book to create. We grabbed stories and anecdotes from our clients and family members and friends, humorous stories from loved ones within the disability community. It's a joyful book. It's a fun book. It's a funny book. If you're interested in stopping by, saying hi, please join us. We'd love to see you. 6 o'clock on the 25th.
I'll be there, and I read the book and I really loved it as well. I can
Oh,
vouch
good.
for you guys
Good.
as well too. It's a pleasure,
Good.
truly.
Thank you.
Thanks so much, everyone. Have a wonderful night. And for those of you who are tuning in later, hope this all made sense. Take care, everyone.
Thank you. Good night.
Thank you.